This week on Lewis on the Law, I have yet another powerful show coming your way. I've got attorney Charlie Fortson in the studio with me, and we're going to talk about discrimination in the workplace.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week, and this week for the next 48 minutes, definitely. I am honored to have attorney Charlie Fortson on with me from the Fortson Law Firm, and we are going to talk about discrimination in the workplace. Now, Charlie, why don't you give them some information about your law practice, what you do, what type of cases you handle?
Hi, my name is Charlie Fortson, and as Lewis said, I am with a Fortson Law Firm. My practice areas include business and technology, and I help small businesses and startups through pretty much every phase of their day-to-day business. So from formation to protecting their trademark and copyright, employee agreements, hiring, firing, software licensing, and other types of contracts. And I also help them with litigation, including breach of contracts, employee disputes, and trademark infringement claims.
That's a lot of stuff right there. Okay, so today we're going to talk about discrimination in the workplace. Does that still go on today?
Absolutely. It goes on pretty consistently. It's actually one of the greatest areas of litigation and also one of the greatest areas of problems for employers because there's so many protected classes that you see discrimination happening sometimes based on different policies that are in place, and then also just kind of as the effect of certain policies that are in place.
Okay, you think by now employers would just treat everybody evenly?
You would think, but it actually gets overlooked a lot of the time. So, for instance, you think that because there's at-will employment that you can pretty much fire someone or someone can quit, but from an employer's perspective that you can fire someone whenever you get ready, just for any reason or no reason. And in most cases you can, but there are exceptions. So for instance, if you are firing someone based on retaliation or you're firing someone based on some type of discrimination, then you cannot do that. And if the employee is able to prove that you somehow discriminated against them, that they are a part of this protected class, then you're looking at a discrimination lawsuit.
Okay, protected class. That's interesting. Now, how did these protected classes come about?
So it started off with there's several different acts that have been put into place that have created these protective classes. I think the one that probably most people are familiar with is the Civil Rights Act of 1964, specifically Title VII. And that was you looking at protective classes such as race, color, sex, national origin, religion. But then you also have these other federal acts or federal laws that were put in place that expanded that scope of protected class. So there's a lot of them. In addition, you have sex, including gender and pregnancy, age, physical or mental disability, veteran status, genetic information, as well as citizenship.
So these protected classes, are these federally protected classes or are they protected by the state?
So the classes that I just mentioned are federally protected classes. However, there are states or each state has additional protections in place or sometimes not as many. So for instance, all of the classes that I just mentioned are federal protections, but the state may expand it if they want to, but they can't narrow it down. So you have at least those federal protections plus whatever protections are put in place by state laws.
Okay, so is this a federal organization or a federal organ that actually monitors this?
Yes. So you have the EEOC, which is the Equal Employment Opportunity Commission. And that is, so in other words, if an employee gets ready or feels like they have a discrimination claim, before they can file that claim, they have to file that claim initially with EEOC. Once EEOC conducts their investigation, they will let you know whether or not you have a right to sue. If they issue you this right to sue letter, then you can proceed with litigation or proceed with a claim against that employer. But before anyone can do it, you have to go through EEOC, and that's for all of the protected classes except for the immigration class, IRCA.
The immigration class, why is the immigration class not protected?
They have a different agency that will conduct the investigations for them. So EEOC handles most discrimination claims.
Will the employers be fined by the federal government also, or the state government, or are they just liable for damages in a suit?
No, what I've seen is when EEOC issues a ruling, from these different litigation cases that have gone forth, then there are certain fines that are put in place. A lot of the times, they will recommend that these employers will create training for all of their employees to kind of teach the sensitivity training, teach about the different laws that are in place. Specifically, we've seen, especially with the Me Too movement, a lot of sexual harassment claims that were filed. And for those, you're looking at anywhere from 50 to 300,000 just for sexual harassment claims alone. But when an employee brings a case, it could be more than just sexual harassment as the grounds for which they're suing. So if there's sexual harassment, but then perhaps there's some other claim that they're making, it could be a disability claim. Then that carries a separate fine. So I've seen awards where it gets into the millions that companies are being liable for behind these multiple discrimination claims.
Into the millions. We were just talking about a personal injury that was for $250,000. Talking about stuff in the millions. In real estate law, we always settle. It's only in the thousands. It seems like I have yet to run into one of those $1 million cases. Maybe I'm in the wrong field of law. I should switch over at some point in time. So does the type of status of the employee matter at all? Say if they're an at-will or contract employee, does that affect their rights under the EEOC?
Absolutely. So when you're looking at these federal laws, it only applies for employers that have, so for the most part, and you can look it up and kind of go into details with it, but for the most part, most companies have to have at least 15 employees. In some cases, it's 20, and they are covered under all of these federal statutes. When it comes to looking at the employees, so for instance, I just said 15 employees, that means that it has to be employees and not independent contractors. Independent contractors are not covered under these federal statutes. So if they feel like they've been discriminated against, there's pretty much, there's no basis for them to file a claim under any of these federal laws that I've mentioned.
Okay, so let me get this straight. If you're a company with less than 15 employees, it's okay to go ahead and do discriminatory employment practices? Or if you've got a couple of independent contractors, you can say, hey, I don't like the way you look.
As best practice, it's never good to discriminate or think that it's okay to do it and get away with it. It's quite possible that there may be some other claims at play. And then also keep in mind that state laws may have different requirements. So there are some, especially in Georgia, some state laws that only require you to have 4 employees. So it's best for each employer to be familiar with the federal laws, state laws, any local laws that may apply for them for wherever they're doing business. And keeping in mind that if you are an employer that is doing business in multiple states, then you need to be aware of the state laws in each state in which you do business.
The states, do they offer, I guess you already said different states differ. Is there ever an issue with preemption, with federal laws preempting state laws?
Well, whenever you're bringing the claim, you're always bringing that claim. If you're filing the claim under federal court, then of course that federal law applies. Now, when you're in federal court, of course you can bring a federal claim as well as a state claim, but you cannot. So the federal law in this case always preempts the state law, but you can also bring a state law claim if it applies to your situation.
Now, does the employer face double liability in something like that?
And that would really be up to the court to decide how they want to, whether it's a jury, to decide how they want to impose penalty. So they would look at what the state law penalties are as well as what the federal law penalties, and then the trier of fact would make that determination.
Sounds awesome. Charlie, why don't you give them some contact information for you?
So I can be reached at charlie@afortsonlawfirm.com. Or by phone, office number is 404-964-2760.
You're listening to Lewis on the Law. On this program, we like to bring you legal information to help empower you, but this is not meant to replace the advice of an attorney. If you have a serious legal issue, you need to go ahead and contract with an attorney. You can always contact me on my webpage, jameslewislegal.com. You can email me at james@jameslewislegal, or you can give me a call at 404-610-0075. And I might be able to help you with your issue. If I can't help you with your issue, I can help direct you towards an attorney who can. A lot of these attorneys appear on my show. Almost every single legal issue is covered. If you have an idea for this show, if there's a topic that you'd like to hear talked about, go ahead and drop me a line, hit me on my contact page, and describe your legal issue, and I'll try and bring on an attorney who actually knows something about your topic and is willing to talk about your topic. When we get back, we're going to take a little look at the federal laws that prohibit discrimination. You are listening to Lewis on the Law, and we've got a little workplace music going on, songs about working too much. Now, that's not a discriminatory practice, but there are other practices that are, and luckily, they're protected by the federal government. You're listening to Lewis on the Law. My name is James Lewis. I am here in the studio with attorney Charlie Fortson of the Fortson Law Firm. Charlie, will you give them some contact information for you again?
Yes. So my name is Charlie Fortson, and my email is Charlie, CHARLIE, at afortsonlawfirm.com. And I can also be reached by phone, 404-964-2760.
Thank you. All my old shows are archived on my website. You can go to jameslewislegal.com and you can check out any of my old shows. A lot of them are on the podcast page. Actually, all of them are on the podcast page, and a lot of them are on my video blog page. We've got some awesome videos. Eventually, every single legal issue you can possibly think of will be cataloged on my website. This show is meant to be a first step in your legal issue, any legal issue you might have. You can go onto my podcast, and it'll help you determine whether you have a case, what type of issues you need to preserve, and what type of attorney you're looking for, or what you might want to look for in an attorney. Now, I've got another powerful and empowering show for you today, and we're talking about discrimination in the workplace. Now, when we left off, we were talking about federal laws that protect you while you're working.
Yes. So we had mentioned before about all of the different protected classes, and you have all of these different federal acts that create this list of protected classes. So there are a couple that we see most often, which is the Civil Rights Act of 1964, Title VII specifically. And then
and that's what you really think of when you think of discrimination in the
Yes.
workplace. You think of that and maybe discrimination against women, basically race and sex.
Absolutely. And under the Civil Rights Act, that's exactly what it includes. It's race, it's color, sex, and it was amended with the Civil Rights Act of 1961 to include PDA, which is the Pregnancy Discrimination Act.
Wait a minute, there's a Pregnancy Discrimination Act?
Absolutely, yes. So,
I thought PDA was Public Display of Affection or something. Like get that out of the workplace.
No, but the Pregnancy Discrimination Act, it helps women, especially when it comes to nursing and breastfeeding, and making sure that there are reasonable accommodations made for women who are pregnant in the workplace. And then you also have national origin and religion. So when it comes to the Civil Rights Act, who are the employers that are covered? It's employers that have 15 or more employees. And again, when we're speaking of employees, we're talking about employees and not independent contractors. And it's very important that...
Well, if you're an independent contractor, you're just out of luck.
And that's the risk you take,
Yeah.
as an independent contractor, you have that freedom to work as you will, but you also you give up those protections that are afforded to employees.
Okay, let's go on.
Okay. And so when you're looking at the Civil Rights Act, some of the claims that you will see by employees is the disparate treatment. So based on a policy that's in place, or just based on kind of like an observable behavior, you see where, it's pretty blatantly obvious that you're being mistreated, and you happen to be a member of this protected class, and you feel like you can prove it. So that's what we're talking about when we're saying the disparate treatment. But then you also have harassment.
Now,
And
isn't there a lot of just different treatment for different people in the workplace? I mean, you see that all the time. I
well,
mean, I worked in a corporate environment, and at times it was a little bit like high school in there. I mean, there were social hierarchies that developed, favoritism, all kinds of things that come into play in a social corporate environment.
and absolutely. But as an employee, when you bring this claim, it's pretty much it's on you as the employee to prove that there is some type of discrimination happening and that you being a part of a protected class, it's happening against you because of your status in this
And it's not
protected
just
class.
part of the corporate culture, because there's some
Absolutely.
beastly corporate cultures out there.
Absolutely. Absolutely. And so when you look at things like harassment, what comes to mind right now is the Me Too movement. And so we've heard the different stories that have been told. So you've got quid pro quo harassment, which is, if you do this favor for me, then you'll get this promotion, or you do this favor for
Whoa,
me.
and we don't want to know what those type of favors are.
Absolutely. But then you also have a hostile work environment. And we saw this with the Charlottesville riots where, there were certain things that were being put out on social media, and certain employees were terminated because those posts that they made on social media created a hostile work environment for employees who were a part of that protected class.
Wait a minute, let's get into that a little bit. What type of, because I actually I don't follow the news that closely
Mhm.
anymore. I'm a little turned off on news because so much of it is so negative.
Mhm.
But what type of posts were those that were posted?
There were posts that were derogatory towards the African American race. And when African American employees saw those posts, then they felt like it created a hostile work environment. Additionally, when an employer looks at those types of posts, they have company policies in place. And if those types of posts do not represent the culture and the policy of that organization, then they can let you go. They can terminate you. And as the employee who made that post, there's not really any type of recourse for you.
Okay, that seems striking, because that's not in the workplace. That's happening outside of the workplace on social media. So that is still applying within the workplace?
Absolutely. It lends itself to creating a hostile work environment.
So you have to watch out what you say on social media, because things you do outside of the workplace, what you think is in your own free time, will come back to reflect on you.
Absolutely. And keeping in mind that, you do have a First Amendment right to write whatever you want to on social media. But as employers, they have a right to enforce their company culture. So they can still terminate you for creating that hostile work environment. And, so it's not violating any type of First Amendment rights, but it is violating their company policy and their culture that they have in place.
That's amazing. I'm actually wrapping my mind around that, and it seems like that has some heavy duty connotations, because then, I mean, you might say we have a workplace culture and we don't want that type of speech going on, and there may be other types of elements where that reaches into. Does that ever affect this? Because here you're talking about first the workplace, and then you're talking about speech that's happening outside of the workplace on your social media in your free time, and how that affects the workplace.
Absolutely, but again, it was a point of controversy.
It seems
Especially
extremely. I mean, and I don't know a lot about employment law, but just hearing this, actually, that automatically I'm thinking First Amendment rights are being violated. How is an employer saying what you can or cannot do in your own free time affecting the workplace?
Well, and that's the thing. They're not dictating what you can say or can't say. They're just simply saying when you say certain things, if it creates a hostile work environment, that you don't have to be employed there.
That seems like that can actually have some other ramifications that we probably won't get into right now.
We won't get into,
yeah, we
but
won't get
who
into it
knows?
because
Who knows?
that seems like that. I mean, then you've gotten into the bullying and the taunting, and are those creating hostile workplaces?
Absolutely.
And social media has become this. I only post certain things on social media. I only post my videos and podcasts.
Yes.
If there's a political debate or something that happens on social media, I will never get involved, because
Right.
that becomes a icky morass of
Absolutely.
horrible things and horrible things that are being said.
Absolutely.
Okay, let's talk about disabilities.
Yes.
Now, I know that people who are disabled are protected in the workplace. There's certain accommodations that have to be made.
Yes. So you have the Americans with Disabilities Act, and that prohibits discrimination based on disabilities. So it also applies to employers with 15 or more employees, and it covers, again, employees and not contractors. So basically, what it says is that employers must provide reasonable accommodations to qualified individuals with disabilities, including both applicants and employees, unless doing so would cause an undue hardship. And so some of the examples of reasonable accommodations include making your facilities more accessible, restructuring a particular job, readjusting the work schedule. And usually, whenever you identify someone with a disability or you think there may be a disability involved, then you have to engage in that interactive process, which is where the employer and the employee sit down and they talk about, okay, what are your needs? What is it that, how can we as an employer accommodate your needs? And, as long as it's reasonable and it doesn't impose an undue hardship on the employer, then it should be implemented.
An undue hardship on the employer, that seems fairly vague.
It is fairly vague, but there are examples out there of undue hardships, and it goes into it's a lot of details involved with it. It gets to be a pretty gray area, but you would pretty much just kind of look at case precedents to see, what did the EEOC
qualifies
or
as an undue
what
hardship?
Exactly.
Sounds like this area of law has a lot of gray areas and a lot of like quicksand type of issues.
It is. It's pretty subjective, and especially when it comes to reasonable accommodations, like what's reasonable, or like you said, the
What's
undue
unduly
hardship.
burden,
What's right, exactly. So when you're looking into those things, it's best to look at, okay, what historically was considered acceptable for reasonable accommodation, or what's considered acceptable as an undue hardship. So having to rewrite your entire policy is probably an undue, could be seen as an undue hardship.
Charlie, we're at the end of this segment. This is a great conversation we're having right now, but give them some contact information for you again real quickly.
Charlie at afortsonlawfirm.com or 404-964-2760.
You're listening to Lewis on the Law, and once again, we are here to empower you, the listener, with legal information. This show is not meant to give you legal advice. Please, if you have a serious legal issue, if you think that you're being discriminated against or you've got a serious legal problem, contract with an attorney. Charlie's here for you. She's given you some contact information. You can always contact me at jameslewislegal.com. Give me a phone call at 404-610-0075 or email me at james@jameslewislegal. When we get back, we're going to continue our conversation on federal laws that prohibit discrimination. You are listening to Lewis on the Law, and I have another great, empowering, awesome, informative show for you. Charlie, who knew talking about the law could be so much fun? It actually is. I have attorney Charlie Fortson on with me from the Fortson Law Firm, and we are talking about discrimination in the workplace. Charlie, give them some contact information for you real quickly, and tell them a little bit about what you do.
Okay. My name is Charlie Fortson with a Fortson Law Firm, and I focus on business and technology law. And you can reach me at charlie at afortsonlawfirm.com or 404-964-2760.
So we're still talking about federal laws that prohibit discrimination, and we were talking about disabilities. How about if I feel like I'm being discriminated against because I am too old? I'm over the hill. These young guys, they don't know anything about it. They don't have to worry about it. But, I'm starting to straddle the other line into middle age here.
Well, there is a law for you.
There is? For us chubby middle-aged guys?
Absolutely. It's the ADEA, which is the Age Discrimination in Employment Act. And it prohibits discrimination based on age. So if you are 40 or over, then this law is for you.
Oh, goody. I have some protection.
You
Not
have some protection.
not that I'm applying for any jobs or anything like that.
But one thing I will mention that, specifically with this law, it applies to employers who have at least 20 employees.
Oh, the number has gone up. It's no longer 15. So if I have 18 employees, I can say, hey, man, you're over the hill.
Right. Well, they probably won't say. They're just going to say, "Oh, your services here no longer needed."
That's terrible. I have a knee that's been bothering me a lot lately, and I've been thinking about walking with a cane, and
Dead giveaway.
it's a dead giveaway. But I thought it would be so cool, and then I could have a collection of canes with multifaceted with wolf's heads and stuff like that. I like collecting stuff like that, but that might give me away. Huh?
That's going to give you away.
Okay. So are there other things we need to look at here? Other federal policies that prohibit discrimination? Is there anything we're missing here?
Yeah, there's several, but I'll just kind of highlight maybe one or two more. So you've got GINA, which is the Genetic Information Non-Discrimination Act.
Whoa, that is a mouthful. The Genetic Information Non-Discrimination Act?
Yes.
What is that?
So it prohibits based on genetic information. So if you think about, employees, sometimes they'll have genetic tests run, or their genetic tests that are, they have run on their individual family members. And, sometimes if you see that, maybe one of your employees, because you have access to some of their health records. So if you see that there's some type of genetic disease that they may have, then there's a tendency to say, maybe they won't be here long. And so we don't want to hire this particular employee, or we don't want to promote them, or we don't want to give them this much responsibility. And that's a form of discrimination under this GINA policy.
Who would have thought? I would have never thought that could have been a discriminatory practice. So if you have werewolves in your family bloodline, you're protected.
Yes. And then I think the last act that stands out, particularly because of a law that was just, or I guess a policy that was just recently passed here, is Equal Pay Act. So the Equal Pay Act prohibits sex-based wage discrimination against men and women who are performing substantially equal work in the same establishment. And we just saw the Atlanta mayor, Keisha Lance Bottoms. She passed this policy that prevents you from asking salary history questions. So one of the things is that this article points out is that women earn 83 cents for every dollar that their men counterparts earned. And then
is that still true today? It felt like that wasn't true in the workplace anymore. Is
no,
that
no,
still
no.
true?
These are recent stats.
Oh my!
And the wage gap widens for women of color. So you're looking at 64 cents on the dollar for African American women and 58 cents on the dollar for Latinas. And so by eliminating the salary history question, you're essentially breaking that cycle. Because a lot of times when we get new positions, they ask, what was your previous salary? And then there's a percentage that they apply that gives you an increase based on that salary history. Well, when you do away with that and you give a salary based on qualifications and experience, now you are paying them based on what they can do as opposed to what they previously made. So you're essentially breaking that cycle of disparity between salaries of men and women.
I think that's actually a really good thing, because I get that question, or I used to get that question when I was out looking for jobs. And my first job out of law school paid pretty well, or I moved up kind of quickly and got paid pretty well. And so all of a sudden people were like, yeah, I'm not going to pay you that.
Right.
And I mean, not that I'm a woman, or, I am a person of color, but, I don't know if I've ever been adversely affected in the workplace. I tend to get looked favorably on a lot of times. I'm not really quite sure why. Maybe it's because I'm a smooth talker.
And a lot of times as women, you don't see that, because of course the salaries are not publicly disclosed, but you do have to report that data, and that's how it's determined that men and women are being paid differently.
Okay, I think this leads us into sex discrimination pretty easily. But I wanted to ask you a question, because you hear a lot, and it's not really gender bias, but it's gender identity bias that goes on. Are there any protections in place now, or is this an issue that's coming up?
Well, you have gender discrimination, which is protected. You have sex discrimination, which is protected. Where it gets gray is when you start having
the gender identity,
the gender
because that's a huge thing.
Exactly. Or even when you start talking about sexual orientation, because right now sexual orientation is not, at least not on a national level, it's not considered to be a part of that definition of sex when you're talking about the protected class. So you've got a case right now before the Supreme Court, Altitude Express Inc. versus Zarda, which the court is basically going to answer that question for us. So you've got where the case where the circuits are split. You have some circuits who are saying that sexual orientation is a part of that definition for protected class, and then you have some courts who are saying it isn't. The EEOC ruled in 2015 that sexual orientation is absolutely a part of sex discrimination. And so now you have the courts who are saying, well, okay, so now that the law is evolving and the interpretation is evolving, maybe perhaps we need to change the way that we're ruling in these cases. And that's what this Altitude Express case before the Supreme Court is all about.
How's that going to go? This court is pretty conservative.
That's probably the million-dollar question, because you have
Is Justice Roberts going to jump ship to the other side?
well, time will tell. Time will tell. So we will see. I will refrain from issuing my opinion until they issue theirs.
Yeah, this show is not about opinions. We just deal with facts and the law as it stands. So give me a little background on how that case came about.
Okay, so there was a skydiving instructor in New York, Zarda. And so if you think about when someone is skydiving, you've got the instructor behind them, and it's very close. And so there could be.
Wait a minute. Are we going to go into a gray area here on
We're going to stop just short of gray.
Okay. Let's not get into anything touchy here on air. But go ahead.
But in in Zarda's attempt to make the female jumper more comfortable, he disclosed the fact that he was gay and he had an ex-husband to prove it.
Oh, okay.
And
okay, good. We skirted across
yes.
the line. Okay.
But when the jump was over, she told her boyfriend that Zarda touched her inappropriately, and it was only after she accused him of touching her that he disclosed the fact that he was gay, so she didn't believe it. So the boyfriend called Zarda's boss. The boss terminated him. Zarda then filed.
So he terminated him not for the inappropriate touching, but because he was because of his sexual orientation.
Well,
seems like the inappropriate touching would be grounds in itself.
Well, the boss said that he did terminate him for the inappropriate touching. Zarda claims no, he was terminated because of his sexual orientation, and that was how the case came. So Zarda, like we mentioned before, reached out to EEOC. EEOC did their investigation and issued a right to sue letter. And they went to court. Trial court said no, sexual orientation is not a part of sex as a protected class. And so, we're going to, do a motion for summary judgment and dismiss that part of his claim. Then he appealed it. Appellate court said, well, EEOC just made this ruling where they said that sexual orientation is a part of the definition for sex. So we're going to overturn the trial court's decision. So then it was appealed to the Supreme Court, and that's where we are now. So each side is, submitted their briefs, and we're waiting to see what the Supreme Court is going to do.
Love taking a look at these Supreme Court cases. I'm really glad you brought that to the table. We're at the end of this segment. Charlie, give them some contact information for you again.
My name is Charlie Fortson. My email is charlie@afortsonlawfirm.com, 404-964-2760.
You're listening to Lewis on the Law. My name is James Lewis, and I am your host for the next 12 minutes or so. But I am here each week and every week, and I'll be back next week with another powerful and informative show. We're talking about discrimination in the workplace, discriminatory employment practices. I'm on with attorney Charlie Fortson. If you have a topic you'd like to hear, an idea for a show, go ahead and contact me on my website at jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can give me a call at 404-610-0075. This show is only designed to give you legal information. It should be your first step in a legal process. It is not designed to replace the advice of an attorney. If you have a serious legal issue, you need to go ahead and contract with an attorney. You can always contact me. I actually am an attorney, believe it or not. I don't only do this. I actually practice law. And if I can't help you with your issue, I may be able to help direct you to an attorney who can help you with your legal issue. When we get back, we're going to talk about considerations for employers. You are listening to Lewis on the Law, and we are here. We're working for you, the people. We're working day and night, and today's topic is about the workplace and discrimination in the workplace. My name is James Lewis. I am your host this week. This is our last segment. I have attorney Charlie Fortson on with me from the Fortson Law Firm. Charlie, give them some contact information for you once more real quickly.
Charlie at afortsonlawfirm.com, 404-964-2760.
And that's a Fortson Law. When you first told me that, I was like, it's a Fortson Law Firm? No, but it's the letter A, Fortson Law Firm.
Yes.
Interesting. And why is that, Charlie?
My middle initial is A.
Oh, okay. And you thought, does that help you? Like, I guess they don't have phone books anymore. Does that help you in listings at all ever?
Anytime there's an alphabetized listing, it absolutely helps.
Oh,
so I always make it to the top.
Is that why you did it?
No, I pay. I'm married, so
Mm-hmm.
Fortson is my married last name, but I love Anderson, which is my maiden name, and so I want to always pay tribute to.
Oh,
both.
I got it. Okay.
Mm-hmm.
I get it. You know, I'm a little slow, but, these things catch up with me eventually. Okay, let's talk. Wait a minute. We've been through a lot here. So why don't we kind of go back through where we've been in discrimination in the workplace?
So, one of the things that I think is important to highlight is that, most states, the default rule in the U.S. is that we have at-will employment.
Mm-hmm.
And most employers...
Okay, let's define at-will employment. What does that mean?
That means that an employer can fire someone for any reason, an employee can quit for any reason. And most times that's okay unless there's some type of discrimination or retaliation that is the cause for this termination. And it's not always a termination. Sometimes it is a denial of a promotion. So anytime there's some type of adverse employment decision, and it's based on discrimination against one of these protected classes that we've talked about, then you're looking at an employee potentially filing a claim of discrimination against the employer.
Okay, so we're talking about federal laws. So what is the process here when you think you have a discrimination case going?
When you have a discrimination claim, then you start with the EEOC. You would file a claim with the EEOC. They would conduct their investigation. If they feel like you have a right to sue, then they'll issue you a right to sue letter. At that point, you have so many days or a few months to file that claim against the employer. And if you're filing a federal claim, then you can file that in state or federal court against your employer.
Now, state court issues, are there lots of states with different policies on discrimination in the workforce than the federal policy?
So, for instance, Georgia has 4 discrimination laws. And theirs is sex discrimination in wages, age discrimination 40 to 70, equal employment for persons with disabilities, and then jury duty and court attendance. So
not every state has jury duty excuse?
No, I mean, some states have jury duty leave,
Mm-hmm.
but we're talking about ways in which you discriminate, and they have a jury duty and court attendance law that says that you can't discriminate against an employee who takes time off for jury duty or to make court appearances.
I would have never thought of that as a discriminatory practice, but here we go.
And interestingly enough, though, Georgia does not have a law for workplace harassment. So if you're going to file a claim for workplace harassment, you're going to file it under federal statute.
Georgia doesn't have a
They do
law for workplace harassment?
No.
So it's okay in Georgia to harass people?
No.
No, because luckily you're protected by a federal law.
Absolutely, there's a federal law. And then one of the things, too, I wanted to add is for employers, consider your employee handbook or your company handbook, because Courts have found that these handbooks can sometimes create a contractual relationship between the employer and the employee. So you want to be very careful and very intentional about the policies that you have in place, you know, as in terms of like governing, how employees would conduct themselves in the workplace. And as in most companies, there is that page that employees sign. So that is where a lot of courts are finding that contractual relationship was created.
I think that's really important. So one of the primary considerations I think that employers should take out of this is go ahead and have an employee handbook and make sure you begin to define what you want your culture to be, because we talked a little bit about culture
Yes,
and how activities outside the workplace can affect the workforce culture.
absolutely. And those are things that you would clearly define in your company policy and or your company handbook. And as laws change, you also want to make sure that your employee handbook changes so that it stays current with and consistent with both federal and state laws.
Okay, so say I'm an employer. How would you advise me to go about building a culture here that will prevent me or will stop discriminatory practices in the workplace from occurring?
So, one of the things that you would put in your employee handbook, but also just as a good policy, is mandatory training. You have certain states like California and New York who passed state and local legislation that requires mandatory sexual harassment training. And it's for managers, it's for supervisors, and it's, depending on the number of employees you have. And even if you don't have, you don't have to be headquartered in those states. You just have to have employees in those states, and then you are required to provide that training. So that is probably the best way. Even when EEOC issues the different verdicts, a lot of the times that requirement is implement training. So you want to make sure that employees, especially managers and supervisors, are aware of state laws, but then also are aware of ways to incorporate diversity and inclusion practices, and also to avoid any type of discrimination in the workplace.
Okay, so we're kind of getting into it. So I'm an employer. How can I minimize my risk?
So one of the ways you minimize your risk is through this company handbook.
Hmm.
And I would say probably, one, first and foremost, know the law.
Hmm.
Have counsel, on hand to always keep you abreast of the law. And then make sure that your company policies reflect the law. And then also make sure that your training is adequate so that, most companies have what you call compliance training. And every year, even if it's just repeat courses, you take these courses that deal with cases such as, sexual harassment, discrimination, diversity, inclusion, and all of these different practices. So your company policy, your training, those should really be reflective of one another. And those together should be reflective of the laws.
Now, we've talked a lot about discrimination in the workplace once you've been hired, but how about during the application process?
Absolutely. So there are different things that you look at in the hiring process that, depending on how you conduct your hiring, you could possibly trigger an employment discrimination claim. Note one thing to note is that these federal laws apply not just to employees, but also to applicants. So some of the things that you may look at is the way that you advertise and describe a job vacancy, the way that you conduct an interview, the way you make an offer of employment, rejecting an applicant, setting compensation in a discriminatory manner. So, again, your training, your company policy and handbook, all of those things speak to the ways that you conduct, all of these different practices. And you just want to make sure that you have adequate training and policies in place for every phase of employment, whether it's the hiring, whether it's during employment, and also in terms of termination.
So let's take a job that has essential functions that are extremely, and we talked a little bit about undue burden to the employer. So how do we take a job that has, say, I am a line cook and I need to flip burgers fast, but I don't want to discriminate against someone in a wheelchair. Is there some sort of medium here?
Yeah, so the same way if you had an employee who suddenly had a disability, you would engage in that interactive process. It's the same thing during that hiring phase. If you have someone in a wheelchair and you can make, well, first off, if they're claiming this disability, you still want to engage in the interactive process even during the hiring phase. And you want to make sure that you can make the reasonable accommodations without the undue hardship so that you can accommodate, a qualified applicant.
You know what? We're at the end of our show. There was a lot of stuff here. I kind of wanted to go back, but I think we're going to run out of time here. So here at the end, give them some more contact information for you and tell them a little bit about your law firm.
Charlie at afortsonlawfirm.com, 404-964-2760. And we are focused on the business and technology. So when you're thinking about a business, think about all of the different phases. So whether it's a startup or whether you're in the growth phase and you're looking to hire, whether you're protecting your assets such as trademarks and copyrights, or you have some type of dispute, then we're here to help those businesses, particularly small businesses, as they navigate through the different phases of their life cycle.
Excellent. Charlie, it's been fun having you on.
Thank you. It's been fun being here.
You're listening to Lewis on the Law. We've had yet another great show. It's awesome that the law can be fun, entertaining, and empowering all at the same time. I've reached the end of this program. I would like to thank the men who make the miracle happen, who keep the dream alive. And Anthony liked this, so I'm going to call him the villain of video, the animal, Anthony Cook over there as our multimedia producer. Our soothsayer of sound, Sam Davis. I like how this just all rolls off the tongue. These guys are making it happen. They're keeping the dream alive. You're listening to Lewis on the Law. I have yet another great show coming up next week. We're going to talk about art in the law.